I will be talking to you today about the rights you may have in tort regarding events between 2010 and 2018. While volunteering at the several churches in London, working at the Tate for 5 years, and visiting Mr. Khan, the breathing specialist. A claim in negligence has 4 components: a duty of care, a breach of that duty, whether you, the claimant, suffered damage as a result, known as causation, and the damage suffered was not too remote. We're going to go through them in chronological order, so starting from 2010, moving away to 2018. The first claim would be from the churches, and on a duty of care that is outside the established duty, through the neighbour principle, which is formulated by Lord Atkin in Donoghue and Stevenson, reading from McBridge and Bagshaw, which Donoghue and Stevenson has now been reformulated because of the Caparo case. There are 3 points that we go from, which is reasonable foresight of harm, sufficient proximity of the relationship, and fair, just, and reasonable to impose a duty. Going from the facts based on the churches, and the several churches in London, we've more focused on the atrium, which we can't determine what solvents were used at any of those churches, and the claim has too many unknown variables for it to be successful. The second, which is the Tate Gallery, which worked out for 5 years between 2012 and 2017 or 2018. There is an established duty, as it's an employer and employee relationship through the neighbour principle of Donoghue and Stevenson. So there is a duty of care there. Whether that duty of care was breached or not, we go from the standard of care of Blyth, did the defendant fall below the required standard of care? And as an employer is required to keep employees healthy and safe in the workplace while working under them. The Health and Safety Act of 1974 means that employers need to do risk assessments, make sure that anything that employees are using, there is safeguards in place to protect them from anything possible that could damage them then or in the future, like inhaling atrium. So the question in law is, was the appropriate standard of care taken? And in this case, it would be making sure that all the protection and precautions are there when using a substance like atrium, which is medically known for causing this rare type of lung cancer, which as an employer, they should know, not you as the employee. They should tell you, and you have the right precautions available and ready for you. So the question of fact is, did they reach that standard? No, they did not. So they breached the duty of care that they owed to you. Moving on to causation, which is normally the but-for test for the factual causation, but sometimes it's harder to prove than just using Cork and Bennett as the case relation for that. So it is the link between the defendant's act or omission and the loss of damage suffered. With regard to the Tate Gallery, as the facts are given, it is part causing a single injury of the lung cancer, and applying Bonington, Lord Keith said that the condition wouldn't have happened or not have occurred when it did, which is more in the case of the Tate Gallery, but for the exposure of the guilty dust, or in your case, the atrium being inhaled. Lord Phillips in Sikowitz said that where the disease is indivisible, which is such as lung cancer, the defendant who has tortiously contributed to the cause of the disease will be liable in full, which is applicable to you. And in Williams and Bermuda Hospitals, which is a recent case in 2016, Lord Toulson follows Bonington in that too. There is also availability for a material increase in risk, which is the exceptional test, and the evidentiary gap, which is an indivisible injury, which is atrium to lung cancer in Rothwell, is used in there, and the single agent, which is atrium, for the evidentiary gap, which is the rock of uncertainty. The principle laid out in McGee, where Lord Wilberforce's said it is the creator of the risk who will bear all the consequences, and the creator of this risk in this case is your employer, so that helps. And then in Fairchild in 2003, only in exceptional circumstances, which I do believe in this case it is, Lord Bingham said the law may justly hold one party liable to compensate the other, which I believe in this case the Tate does towards you. And policy militates in favour of compensating those who have suffered grave harm at the expense of their employers who fail to protect them from that harm, which again, is self-explanatory, that is what they have not done for you. Lord Nichols said that in rejecting the claimant's claim in Fairchild would have been deeply offensive, which I believe it would be deeply offensive to reject your claim against the Tate in this case. It then moves on to remoteness, which is referred to as legal causation or causation in law, for how much of the claimant's loss should the defendant be responsible for. And the test is in R.E. Polonis, I think, where the damage is in fact traceable to the negligent act, which in this case it would be as well, looking at overseas tank ship in correlation to that also. As it was a non-intentional tort, Wagon, the case, states that to be recoverable, damage must be of a reasonable, foreseeable type, which in this case I do believe it is. And in Hughes's was, it's not relevant how it happened, just that it has to be of a foreseeable type. And if the research and the background and the risk assessment was done correctly, then it would be of a foreseeable type of intention. So it wasn't too remote. The defences that the Tate could have are of contributory negligence, because you did use the atrium before in your own personal paintings, and it could be proven that you did use it at some point before that as well, given the facts. The law reform of the Contributory Negligence Act 1945, section 1.1, says that it reduces the level of damages payable to the claimant, contributing to their own injuries, which it can be proven that you did. So that is their defence, using Jones, Badger, St George, all of these cases. Would you expect someone in your profession who works with it on a regular basis and knows about all this kind of things to have known about it? And they will question that, obviously. And it's all about the appointment of blame, so it can be shared in this case, and the causation and culpability. So the court will have to decide of how much blame there is to appoint to you and the defendant, so whatever they feel. Moving on to the third claim, which is the doctor, which is an established duty between doctor and patient. Mr. Khan has a duty of care towards you. Whether he breached that duty or not is very, very specific. As this was a skilled task, it slightly differs. So it's would the reasonable person of his profession have acted in the same way that he did. And we look at a case of Bullen, where McNair said if there is an established duty of opinion in support, it is reasonable. So if a medical examiner says that they would have acted in the same way, then it can be seen as reasonable, and he did not breach his duty. However, in Bolitho, I think it is, Lord Brown Wilkinson said that the medical opinion is and has to be logical, and so it's in a response of relying too much on professionals to decide cases, where a court should have more jurisdiction to intervene. So there is a small chance that can be a breach found under these circumstances. It comes down to the court's interpretation and acceptance of the medical opinion given that will be given in defence for the doctor's breach of duty. If there is a breach of duty found, there is a loss of chance. It will be down to the loss of chance in Hughes, Gregg versus Scott. If the chance of recovery can be found over 50%, then you get damages for the ultimate injury. But if there is less than, using allied maples, you cannot get damages for the loss of chance. And because it's between 45 and 50%, it's down again to the decision of Gregg and Scott. As the decision was held 3-2, held against the claimant, the courts are very reluctant to impose liability in cases like this. Damages that are available are those that are capable of being calculated at time of trial, known as general damages, future earnings, future medical expenses and the pain and suffering you have been involved in, and also special damages prior to trial, loss of earnings, and the medical before you're involved in all of this mess. Thank you.